Okay, welcome. I'm Lauren. I am the co-executive director of the LGB Courage Coalition. The LGB Courage Coalition is a lesbian and gay advocacy group committed to promoting evidence-based medical care, ending the medicalization of gender nonconformity, safeguarding homosexual rights, and building a pathway back for LGB individuals who have undergone medicalization. We believe no child should be subjected to the material harms caused by puberty blockers, cross-sex hormones, and gender-affirming surgeries. We're a registered nonprofit based in the United States, completely funded by small donations. Please feel free to use the chat and ask questions. We have 30 minutes allotted at the end for Q&A. This is the first in a lecture series that we will be putting on for paid subscribers to our Substack. And Kara Dansky has given us the honor of being our first lecturer. Kara Dansky is an author, lawyer, feminist, and lifelong Democrat. She has published 2 books on the threats that the concept of gender identity posed to women and girls: The Reckoning, How the Democrats and the Left Betrayed Women and Girls, and The Abolition of Sex, How the Transgender Agenda Harms Women and Girls. And she publishes a newsletter called The Turf Report on Substack. She served as president and member of the board of directors of Women's Declaration International USA from 2021 to 2024, and as a member of the board of directors of the Women's Liberation Front from 2016 to 2020. Before turfing herself out of a career, Kara was nationally recognized expert on criminal law and justice policy and served as senior counsel on criminal justice policy at the ACLU from 2012 to 2014. She has a JD from University of Pennsylvania Law School and a BA from Johns Hopkins University. And with that, I'm going to hand it over to Kara.
Thanks so much, Lauren, and thanks to everyone who's attending tonight. So I need to say at the outset that I don't mince words. I've been fighting for the sex-based rights of women and girls and to stop the abolition of sex and to protect kids for 10 years since I joined the Women's Liberation Front in 2015. I will always put gender identity and trans in quotes. I don't use so-called preferred pronouns, and I have no problem so-called dead naming anyone whose birth name I know. I don't use any language that was invented by gender identitarians. I don't even refer to them as so-called trans rights activists anymore because trans is not a civil rights movement for a group of people. It's a male sexual entitlement movement that is being driven by a multi-billion-dollar industry. Nothing I say is sugar-coated, and in the past 10 years, I have found no reason for compromise. As I said in my first book, The Abolition of Sex, I think the most compassionate thing we can do for anyone who is confused about his or her sex is help them accept material reality. So with that, let's get to it. First of all, what is meant by self-identification, or as it's more generally known, self-ID? Let me go ahead and share my screen. I forgot to do that. Is that good? Okay.
Perfect.
Okay. Self-ID refers to the concept that a person can be considered legally or otherwise a member of the opposite sex for various purposes based purely on self-identification. Now, those of us here tonight care very much about the fact that many young people, including many young people who will grow up to be lesbians or gay men, are taking hormones and having surgeries to more closely resemble the opposite sex. That's horrible. And I am in awe of the LGB Courage Coalition for its advocacy in stopping it. Self-ID is different. It's the idea that a person can simply be recognized as the opposite sex on the basis of the person's say-so. So the easiest way to understand how we got to this place is to go back a few decades and work our way forward. So let's start in the UK with a few legal cases culminating in the enactment of the Gender Recognition Act of 2004 and proposed changes that came about in 2018. Perhaps most importantly for lesbians and gay men, the history of self-ID is very closely linked with same-sex marriage rights in the UK. So for a lot of this introductory discussion, I'm relying on a paper titled The Gender Recognition Act, Past, Present, and Future by Lauren Percy, which you can find in the St. Andrews Journal. In 1963, a man named Arthur Corbett married April Ashley in the UK. Same-sex marriage was not legal in the UK at the time. April Ashley was a man who was born in the UK and in 1960 had so-called sex reassignment surgery in Casablanca, Morocco. He returned to the UK at some point and married Corbett. However, they did not appear to like each other very much, and a few years later, Corbett asked a court to dissolve the marriage on the ground that Ashley was male. The court did so. In its opinion, the court said the following: having regard to the essentially heterosexual character of the relationship which is called marriage, the criteria must, in my judgment, be biological. My conclusion, therefore, is that the respondent, meaning Ashley, is not a woman for the purposes of marriage, but is a biological male and has been so since birth. So this judge was essentially saying that marriage is fundamentally an institution between straight people, and because Corbett and Ashley were both male, the marriage was null and void from the start. The judge wasn't exactly wrong legally, because the UK did not have any legal way of recognizing a same-sex marriage at that time. That happened in 1970. Christine Goodwin is a man who sued the UK in 1995, alleging that the UK was in violation of the European Convention on Human Rights because the UK did not recognize him as a woman legally. He had had genital surgery, and the European Convention ruled that logically, according to it, there was no good reason for the UK not to recognize him as a woman. It essentially told the UK to get to work on so-called gender recognition. 9 years later, it did so with the enactment of the Gender Recognition Act of 2004. Now, the Gender Recognition Act of 2004 is an absolutely nonsensical piece of legislation, but it was seen as necessary because same-sex marriage wasn't lawful. The idea was that in order for a same-sex couple to marry, one of them would have to be legally recognized as a member of the opposite sex by getting a gender recognition certificate, or GRC. But it's all grounded in sex stereotypes. This is the opening text of the Gender Recognition Act. The law allows people to apply for what's called a gender recognition certificate on the basis of, quote unquote, living in the other gender, or quote unquote, having changed gender under the law of a country or territory outside of the UK. The law refers to something called an acquired gender, which is said to mean the gender in which a person is living. In order to get a GRC under the GRA, a person has to first have a diagnosis of gender dysphoria, second, have lived in their acquired gender for 2 years prior to the application, and third, declare his or her intention to live in his or her acquired gender until death. The person has to present a report by a registered medical practitioner in the field of so-called gender dysphoria, as well as a second report by a different medical practitioner. And the reports had to detail the diagnosis of gender dysphoria and provide details about so-called treatment. The application then goes before a gender recognition panel for evaluation, and this is all still good law today. But what on earth does it mean to live in a gender? What can it possibly mean other than sex stereotypes? Every person here tonight is either female or male. We all, to varying degrees, either conform to or don't conform to the stereotypes associated with either sex. All of this is pure gender nonsense. And the fact is that in 2004, the UK could have just legalized same-sex marriage. But instead of just letting gay people marry each other, it enacted this nonsensical enshrinement of sex stereotypes in the law. There's a big push in the UK today to get the GRA repealed on the ground that no one should ever be recognized as the opposite sex in the law at all. I would support that if I lived in the UK. Incidentally, the UK finally got around to legalizing same-sex marriage in 2013, which makes this whole GRA thing totally unnecessary anyway. Even though the GRA of 2004 is utter nonsense, it at least provided some requirements before a person could be considered the opposite sex legally, which brings us to self-ID. In 2006, a bunch of people got together in Yogyakarta, Indonesia, and put together what came to be known as the Yogyakarta Principles. They essentially said that the concept of gender identity should supersede the material reality of sex for all purposes under international human rights law. Note here the phrase sexual orientation and gender identity. Now, people here are, of course, familiar with the many ways in which so-called trans has succeeded in large part by getting the T glommed on to the LGB. This is another way they've done it. They constantly repeat the phrase sexual orientation and gender identity as a way of making people think that so-called trans is somehow related to sexual orientation. Proponents of the Yogyakarta Principles have been running around the world ever since then, telling governments that they're binding, but they're not. Still, they have had a tremendous amount of influence on many governments, including in the US. The Yogyakarta Principles were updated in 2016, and 2 years later, something critical happened in the movement to abolish sex at the altar of gender identity and self-ID. As stupid as the Gender Recognition Act of 2004 is, in 2018, the UK government proposed getting rid of all requirements for obtaining a gender recognition certificate and proposed allowing anyone to get a GRC simply by declaring themselves to be the opposite sex. The government was proposing to reform the GRA by eliminating any gatekeeping for anyone to be considered the opposite sex legally. The argument in favor of this was that gatekeeping violated the human rights of trans people by denying them the right to have their so-called gender identity acknowledged in the law. Feminists in the UK pretty much went berserk and basically said, oh, hell no. People often ask me why the UK is so much further along in terms of the movement to protect the sex-based rights of women and girls. And I think this is one reason why. In the UK, the GRA so-called reform proposal was made very public and ignited a massive outrage. Nothing like that has happened in the US. And here, many people are still in the dark about what is happening. That's not going to change until the media gives a voice to groups like the LGBT Courage Coalition, Women's Liberation Front, and Women's Declaration International USA. Anyway, feminists in England got the government to scrap the GRA so-called reforms, but a related measure passed in Scotland in December of 2022. Thankfully, the government in London was able to block the Scottish measure from taking effect. So self-ID is not in effect anywhere in the UK, largely thanks to British and Scottish feminists. But it is in effect in Germany, which voted to pass it in May of 2024. The law went into effect in November of 2024, and it was recently announced that a male neo-Nazi has been permitted to be housed in a women's prison on the basis of his so-called woman identity. This is him. This is self-ID. If there's time, I'd like to play a 10-minute video of women protesting against self-ID globally that happened on November 1st in 2024. Self-ID is also in effect nationwide in Spain, which passed a similar law in 2023. It's the law of the land in other countries too. Now we have to go back in time again, this time to 2012. Very few people know this, but 2012 was a major year for the movement to abolish sex and replace it with so-called gender identity. In 2012, for example, Argentina became the first country to enact a nationwide self-ID law. Since 2012, people in Argentina have been able to be considered the opposite sex for all purposes. Also in 2012, a young man named Tim McBride decided that he's a woman named Sarah, graduated college, and landed himself an internship at the Obama-Biden White House. As many of us know, Sarah is now a sitting member of Congress. We can get into more details of McBride's relationship with the Biden family if you'd like. They're very tight. 2012 was also the year that Biden began declaring that transgender discrimination is the civil rights issue of our time. It's also the year the Bureau of Prisons at the federal level began allowing men to be housed in U.S. federal women's prisons. Okay, so let's talk about self-ID at the federal level in the U.S. The United States does not have an explicit self-ID law at the federal level like they do in Germany, Spain, and Argentina, in addition to other countries. There's no mechanism through which a person can simply be considered the opposite sex as a legal matter at the federal level. But that's not for lack of trying by Presidents Obama and Biden and congressional Democrats. In May of 2016, President Obama's Departments of Justice and Education jointly issued what's called a Dear Colleague letter. You don't have to read all of this. I'm just showing you the evidence that it's true. It was a letter to schools all over the country telling them that sex means gender identity for all purposes under Title IX, which prohibits sex discrimination in education. This was essentially saying that schools should consider girls to be boys and boys to be girls upon a student's say-so for all purposes, including sports and bathrooms. It was self-ID. The Women's Liberation Front sued the administration over this letter in a case titled Women's Liberation Front versus United States of America. Incidentally, one of the named plaintiffs in the lawsuit was Vanita Gupta, who at the time was the Assistant Attorney General at the Department of Education and authored this letter. Vanita was also my boss when I worked at the ACLU from 2012 to 2014. So that was interesting. That letter was withdrawn by Trump in early 2017, but it had already done its damage. Students all over the country started suing their school districts, alleging that their school districts were in violation of Title IX if their schools didn't let them use an opposite-sex bathroom or locker room. In 2015, Oregon Senator Jeff Merkley introduced a bill called the Equality Act in Congress. It would redefine the word sex to include so-called gender identity for literally all purposes under United States civil rights law, including public accommodations. A public accommodation is basically any business that is open to the public or a public area. The phrase includes all restaurants, bars, movie theaters, gyms, airports, and the like. If this bill were to become law, it would be illegal for any place of public accommodation to maintain a strictly single-sex bathroom. Any man would be permitted to walk into any women's bathroom or locker room or changing room on the basis of his self-declared gender identity. He wouldn't even have to produce a piece of paper saying that he's a woman. He just needs to say, I'm trans. That's self-ID. And it would be the law of the land if this bill were ever to pass. The bill has been introduced by congressional Democrats in every session of Congress since 2015, including in this year. And the Human Rights Campaign has put together a coalition of over 500 businesses that support it. Thankfully, it has never passed, and I have some ideas as to why. There's a lot more to say about that if we have time. So, in January of 2021, on his first day of taking office, President Biden issued Executive Order 13988 on preventing and combating discrimination on the basis of gender identity or sexual orientation. Notice again the conflation of sexual orientation and so-called gender identity. This order required all federal agencies to redefine the word sex to include so-called gender identity under every single provision of federal administrative law. Between 2020 and 2024, virtually all agencies did so. Now, importantly, this executive order was said to rely on the 2020 Supreme Court decision in Bostock versus Clayton County. The case that became Bostock was originally three cases, two cases involving gay men who had been fired for being gay, and one case involving a man named Amy Stevens who called himself a woman and demanded to use the women's room at work. The Supreme Court ended up deciding that employment discrimination on the basis of sexual orientation or so-called transgender status constitutes unlawful sex discrimination under federal employment law. It did not say a word about what it meant by transgender status, and courts have been grappling with this ever since. In this executive order, Biden said that the Supreme Court said in Bostock that sex includes gender identity for all purposes, but it didn't. The Biden administration spent all 4 of its years lying to the American people by saying that the Supreme Court demanded sex self-ID for all purposes. The Bostock decision was bad because it didn't tell us what transgender means, but the Biden administration made everything much, much worse. Trump rescinded this executive order on his first day of taking office. In 2022, President Biden's Department of Education announced changes to the Title IX regulations. As I mentioned, Title IX prohibits sex discrimination in education. It was enacted in 1972, and the regulations were issued in 1975. Those regulations explain the implementation of Title IX, and they explicitly allow for single-sex bathrooms, dormitories, sports, and some other things. Biden's proposed regulatory changes would have shredded all of that and allowed anyone to self-identify as the opposite sex. In case you think I'm exaggerating, I promise I'm not. In April of 2024, the department announced that they were final, the rule changes were final, and set to take effect on August 1st, 2024. A flurry of litigation ensued, with multiple federal courts ruling that they were illegal. Finally, in January of 2025, a federal judge vacated the rule changes completely. Now, there's a lot to say about litigation concerning so-called gender identity because there are a ton of US cases about it. We can get into Scrimetti during Q&A if you'd like. The crux of the matter, in countless cases that have been going on since around 2015, is whether sex is real in the law. Many people who call themselves transgender or queer or claim to have an opposite sex gender identity have been arguing for a long time that sex simply isn't real, or that if it is, gender identity is more important. This has happened again and again in many contexts. In numerous cases, students who claim to have opposite sex gender identities have sued their schools for maintaining single-sex bathrooms. Some have sued states for requiring single-sex sports in the law. Sometimes these kids are on hormones, and other times it's purely a matter of self-identification. As incredible as it sounds, the federal courts are currently split on the question of whether schools are even allowed to maintain single-sex bathrooms under both Title IX and what's called the Equal Protection Clause of the 14th Amendment. Both the Fourth and Seventh Circuit Courts of Appeals have ruled that schools are not allowed to maintain single-sex bathrooms. The 11th Circuit ruled in the opposite direction. The courts have generally been pretty disappointing in their apparent refusal to address the question of the material reality of sex head-on. It happens outside the school context too. A man once sued a beauty pageant because it had a female-only policy and he claimed to be a woman. He argued that the pageant's policy violated Oregon state law. Happily, he ended up losing. A group of sorority women once sued their sorority because it allowed a man in on the basis of his self-identification as a woman. They alleged that he would walk around the sorority house gawking at women while sporting an erection. Unfortunately, the sorority women in that case lost. A man once sued a female-only nude spa in Washington state on the basis of his self-identification as a woman. He argued that the spa's female-only policy violated Washington state law. It turns out he was right. He won. And then he won again on appeal. The spa has asked for the matter to be reheard, and we're waiting for the Court of Appeals in that case to decide whether it will be. Once a group of lawyers sued the Biden administration, a group of doctors sued the Biden administration, worried that they were going to lose federal funding if they didn't acknowledge their patients' gender identities in the practice of medicine. One of the doctors had a male patient who had refused prostate cancer screening because he claimed that because he self-identified as a woman, he couldn't possibly have a prostate. Two major cases to watch now are Little v. Hecox and West Virginia v. BPJ. Both are currently before the U.S. Supreme Court. Little here refers to the governor of Idaho. Both Idaho and West Virginia have passed laws protecting female-only sports. In Idaho, a grown man who self-identifies as a woman sued the state, demanding to participate in female-only sports at his college. That case has been pending for 5 years. In West Virginia, a minor boy whose puberty has been blocked sued the state, also demanding to participate in female-only sports. Both male athletes won their cases, which both went up on appeal. On appeal, both male athletes won again. So now the Supreme Court is finally getting involved. Another case to watch is Gaines et al. Versus NCAA et al., where Riley Gaines and several other female athletes have sued the NCAA for allowing Will Thomas to compete in the 2022 National Women's Swimming Championships. That lawsuit is supported by the group Independent Council on Women's Sports, or ICONS. I'll say one more thing about self-ID at the US federal level. Before 2010, in order to change your sex marker on your passport, you had to provide proof of genital surgery to the State Department. Now, I don't like that because no one changes sex, even if you have surgery. But still, that policy presented some gatekeeping. However, in 2010, as Secretary of State, Hillary Clinton changed the policy by making it possible to change your sex marker on your passport with nothing other than a doctor's note. She did it very quietly with zero media fanfare. It didn't exactly make passports a matter of self-ID because it still required a doctor's note, but it came pretty close. Very few people know this because no one talked about it at the time. But here's this 2016 article in Politico that talks about it. In 2016, of course, Hillary was running for president. That year, Politico ran this story: "My country accepts me as a woman. Hillary Clinton was the force behind a little-known breakthrough in transgender rights, so why doesn't she talk about it?" It presents the story of a man named Jackie Richter, who owned a construction company in Illinois. He got his sex marker on his passport changed to F under the new policy and got his construction company registered as a woman-owned business on that basis, earning him numerous tax breaks that are supposed to be designated for women. Now, I'll just go on a side tangent for a minute. I know a woman who is personal friends with Hillary Clinton. They speak regularly, if not daily. She got me a ticket to Hillary's campaign launch in New York in 2015. We met regularly for lunch or coffee when I lived in DC. I asked her once in 2020 what Hillary Clinton thinks about trans. My friend quietly shook her head and mouthed the word passports. She was basically telling me that Hillary couldn't talk about it because the passport policy got changed under her watch as Secretary of State. We were at a public event at the time, and I didn't push the matter. but I did push it with her last year. I was extremely worried that the Democratic Party's utter refusal to address this issue head on, not the passport issue, but the issue generally, was going to cost them the presidency. I thought that by this point, surely I could get through. I thought that if my friend could get through to Hillary, then Hillary could get through to Harris, and the Democrats could finally get this right. I texted my friend to see if she would talk. She said she would talk, and I mentioned something about trans. My friend texted back, I am not talking about trans issues. I asked again, gently, and explained that I was worried that this was going to cost the Democrats the election. She responded again, Kara, I'm happy to talk with you, but I am not going to talk about trans issues. This was not me shouting into the wind. This was me talking directly with a woman who has the ear of Hillary Clinton, who could have steered the ship in the other direction. My friend refused, and here we are. As we know, Trump has reversed the State Department's policy on passports. Okay, everything I've talked about so far is just the tip of the iceberg with respect to the state of play at the federal level. But the US is essentially 52 separate governments, all 50 states, the District of Columbia, and the federal government. On the topic of self-ID, states are all over the place. Most, probably all, states have laws that prohibit discrimination in places of public accommodation. These were basically passed in the wake of the Federal Civil Rights Act of 1964, and all were meant to prohibit Jim Crow racial segregation. Many of them have been amended over the years to add various categories, including frequently national origin, religion, disability, and sex. And in many states, places of public accommodation are not allowed to discriminate on the basis of people's self-declared gender identities. California has a law in place saying that all persons within the jurisdiction of the state are free and equal, and no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, sexual orientation, citizenship, primary language, or immigration status, are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. Fabulous. Then, the law goes on to define the word sex. This is what it says. It says that the word sex includes but is not limited to a person's gender. Gender means sex and includes a person's gender identity and gender expression. Gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's sex assigned at birth. Now, to the extent that that's intended to prohibit discrimination on the basis of sex stereotypes, great. But beyond that, if any of you can figure out what it all means when it comes together, feel free to let me know. I think it's self-ID. The LGB Courage Coalition might also be especially interested to know that Washington state law defines the phrase sexual orientation to include gender identity for all purposes. This is the law on which the man sued the female-only nude spa in Washington. He's a straight man who calls himself a woman, but because of the way Washington state frames the law, he was able to claim that the spa was discriminating against him on the basis of his sexual orientation, because his sexual orientation allegedly includes his woman gender identity. Now, clearly, if this spa were ever to discriminate against an actual lesbian, that would be an obvious sexual orientation. That would be obvious sexual orientation discrimination. But this was a straight man. States also have different laws addressing the placement of prisoners. In 2020, the California legislature passed and Governor Gavin Newsom signed a law that allows any male prisoner to be housed in the main California women's prison solely on the basis of self-identification. Dozens of prisoners have been transferred on that basis. One of them has been criminally accused of raping two female inmates and is currently awaiting trial. In New Jersey, the system allows self-ID with respect to prison placement thanks to a settlement agreement entered into between the State Corrections Department and the ACLU. Washington State allows prison placement by self-ID via an administrative policy. Incidentally, the crime of conviction is never relevant to the question of where an inmate is placed. I'm aware of male inmates who have been convicted of multiple counts of murder and rape being housed in women's prisons. I'm sure there are other states with self-ID prison placement policies, and all of the other states, to a certain extent, allow men to be housed in the women's prison after meeting certain requirements. Everything is even more confused by the fact that things like driver's licenses, and birth certificates are determined by state law. It's not really possible for me to know all 50 state laws and policies about these things, but helpfully, trans groups do it for us. There's a group called the Movement Advancement Project. This group works with the Trevor Project to trans kids. It has a database that tracks identity document laws and policies. I'm sure states are all over the place in terms of what they require for amending such documents. Some probably have tight restrictions on who can get their documents changed, and others probably allow for self-ID. For anyone who doesn't remember, a man named Darren Morager once caused controversy by parading around the women's section of a nude spa in LA. He later did an interview where he said he was able to walk right into the California DMV and get an F marker on his driver's license. I looked it up, and it's true. The California Gender Recognition Act allows state residents to self-certify their gender identity as male, female, or non-binary on a driver's license effective January 1st, 2019. I'm sure it's the same in other places. I know it's the same in Washington, D.C., because I once lobbied to prevent D.C.'s law to the same effect from being passed. So the bottom line is that even though the US does not have a federal self-ID law, the truth is that whether people can self-identify as the opposite sex or as a member of no sex or as a member of a third sex that doesn't exist is a patchwork across all 50 states and the District of Columbia. So I will end by discussing a 2007 article in Salon magazine titled, "How Did the Tea Get in the LGB?" by John Aravosis. Aravosis is a gay guy who speaks 5 languages, incidentally. He's a frequent commenter, and he's been published in countless publications over the years. He lives in DC, and he works as a Democratic political consultant. He says in this article, and I'm quoting here, so please don't get mad at me. He says, quote, "In simpler times, we were all gay, but then the word gay started to mean gay men more than women, so we switched to some more inclusive gay and lesbian. Bisexuals, who are only part-time gays, insisted that we add them too, so we did, not without some protest. And by the early 1990s, we were the lesbian, gay, and bisexual, or LGB community. Sometime in the late 90s, a few gay rights groups and activists started using a new acronym, LGBT, adding T for transgender or transsexual. And that's when today's trouble started." So Aravosis goes on to tell the story of the Employment Non-Discrimination Act, or ENDA. ENDA would have made it illegal for an employer to fire or refuse to hire or promote an otherwise qualified candidate simply because of their sexual orientation. Aravosis continues, and again, I'm quoting here, and this is from 2007. ENDA was first introduced 30 years ago. In all that time, it only protected sexual orientation and never included gender identity. This year that changed, and gender identity was added to the bill. Coincidentally, this year is also the first time that ENDA actually has a real chance of passing both the House and the Senate, but only if gender identity isn't in the bill. So the bill's author, openly gay Representative Barney Frank, dropped the transgendered from the bill, and all hell broke loose. Gay activists and 220 national and local gay rights groups angrily demanded that gender identity be put back in the bill, guaranteeing its defeat for years to come. Many of them, suddenly and conveniently, found all sorts of flaws with the legislation that they had embraced the previous 29 years. They convinced House Democratic leaders to delay action on ENDA till later in October. They'd rather have no bill at all than pass one that didn't include the transgendered. Aravosis was angry that some activists were intent on ruining a perfectly good piece of legislation authored by Congress's first openly gay member to protect gay men and lesbians in employment. Now, I have no idea what he thinks about any of this today, and I suspect that if confronted with this 2007 article, he would likely recant his 2007 heresy. His reputation as a DC resident and Democratic consultant is, of course, at stake. As far as I know, ENDA has never passed because of the insistence of some groups, starting all the way back in 2007, that it include so-called gender identity as a protected category. Today, of course, no one can be fired for being gay because of Bostock, which is good. But Bostock was decided in 2020. Our country could have won a major gay rights victory in 2007, but for the inclusion of gender identity, which is self-ID, in the bill. I have reason to know that Barney Frank is totally on our side in this battle for obvious reasons, but I've never heard him speak about it publicly. This image is J.K. Rowling holding up her notebook in the back seat of a car or a limo or whatever. It was taken from the video that I'd like to play if there's time of a global women's protest in November 2024 against self-ID. At its core, self-identification refers to the ability to claim to be the opposite sex, neither sex, or a member of a mysterious third sex class that doesn't exist. It's a complete fabrication. My personal view is that any lie about sex is unethical and ought to be illegal. I wish people would not claim any of these things, and I wish people would not take harmful hormones or have surgeries that harm their bodies. I don't think anyone should be recognized as a sex other than their real sex under any circumstances. But self-ID at its core is the complete elimination of any requirement to demonstrate that a person has taken any steps at all to resemble the opposite sex. It's a lie and it needs to die. Thank you.
Thank you so much, Kara, for that amazing presentation.
I was supposed to talk for an hour and I came in at 45 minutes. I hope that's okay.
It is absolutely okay. I was afraid you were going to go much, much longer, since you said you didn't time yourself. That was really, I actually learned a few things too, so that's always a good sign. What I'd like to do is start opening up for questions. Questions, comments. I've got the Q&A box open. If you want to put a question in there, we can do so. Kara, as we're waiting for questions to come in, I had a few just questions to see if we could check in on a couple things. So with this new administration, the passports have been changing. Is it similar to what happened with Clinton and how it went in one direction? Is this more of a bureaucratic switch that's pulling it back? Can you address that a little bit?
My understanding is that all passports are being changed to accurately reflect sex. If that's true, that goes further than it even did before Hillary Clinton. Because before Hillary Clinton, you had to have a surgery.
Yes, correct.
She eliminated that. My understanding is that under the current administration, even surgery doesn't get you an opposite sex marker on your passport.
Do you have any idea how they're making the determination to do this reversal, or if it's coming in as people apply for a new passport?
I'm relatively confident that as people apply for a new passport, they'll confirm sex, but I don't know how they're changing old ones back.
Okay. Thank you for that. So, a follow-up question I have. Um, we are seeing some states pass laws about the recognition of only two sexes. Um, are those laws drafted in such a way that they are immediately kind of going into the state identification channels, or does that something still where the states then have to take that and put it into interpretation for things like their driver's license and things like that?
So I am most familiar with something called the Women's Bill of Rights, which was co-authored by the Women's Liberation Front and Independent Women's Forum. And WDI USA supports that legislation. It's a model bill that any state can adopt. So that's a very well-written piece of legislation that defines things very accurately. And some states have adopted the model bill to enact in their states. My understanding is that once those take effect in the states, they're in effect in the states, and state agencies have to comply with them. That's generally how it works. State administrative agencies have to comply with laws passed by the state legislature.
Got it. Okay. Thank you for that. As we see this administration pushing, I've seen some comments or clips on the more global level where this administration is talking about biological sex and policy work that involves things like the World Health Organization or bigger international policies. Have you seen anything at that level occurring?
So gender identity is all over the world. The United Nations is totally infected with this stuff, with the sole exception of Reem Al-Salem, who's the special rapporteur on violence against women and girls. But besides her, so-called gender identity permeates everything at the UN. There's a guy called Victor Madrigal Borlos, who was in office 2018 to 2023 as the I don't know, independent something on gender identity, basically. And so he ran around the world telling everyone that they had to adopt gender identity policies. He's still busy doing that, but no longer at the UN. But yes, the World Health Organization, WEF, the World Economic Forum, all of them have swallowed all of this gender identity stuff.
So even the administration with all of its current power, we still would have to look at this as a global kind of issue.
We definitely have to look at this as a global issue, which is why Women's Declaration International exists to deal with the issue globally. But also, I'll say sort of tongue in cheek, I don't know that America has ever really cared much about what international law has to say about anything. So, we're just going to go ahead and do what we do.
Okay. Not totally tongue in cheek. Okay, I'm going to read to you from some of the chat and Q&A. We've got a great job, Kara, as well deserved. Was something renamed as Stand with Women? Something
Not in America.
Okay.
Kelly J. Keene's group, I think is called Standing for Women.
Okay. A comment, I'm finding it frustrating to explain and then re-explain to my friends where I live in a age 60 plus building in Massachusetts, the basics of the problem with self-ID. Simply breaking through the adoration by some of my female peers of individuals such as RuPaul is a struggle. Do you have an elevator pitch? If you had to maybe explain self-ID in like 2 sentences for somebody to care, how would you maybe frame that?
Well, I mean, I would just say that self-ID means that anyone can just be considered the opposite sex for any reason at any time. But an elevator pitch on self-ID isn't going to help the questioner because RuPaul's a different kind of thing, right? Like nobody, like the questioner's friend likes RuPaul because, he's in many ways a sympathetic gay man. And so it's really important for people to understand that trans is not super gay.
Yes. It's not gay 2.0. Yes. Okay. Kara, are you aware of any notable Dems who are closeted allies?
No,
You
but
mentioned one towards the end.
notable Dems who were closet allies. What did I say?
Who I'm gonna draw a blank on the name. Who,
Okay. Oh,
but
Barney Frank.
yeah, Barney
Right.
Frank.
Okay. Yeah. But he's not in office currently. I think
Okay.
he Um, there was an interview that Hillary Clinton did, and by the way, I'm not necessarily a Hillary Clinton stan. I don't care if you love her or you hate her. I'm not saying anyone needs to like her. It's fine. I'm just saying she's relevant to the conversation. She gave an interview in 2023, I think, and the interviewer said something along the lines of, should the Democratic Party be talking about gender identity, and does it make sense to call J.K. Rowling a fascist? It was a very pointed question, and Hillary addressed it without missing a beat by essentially saying Democrats need to shut up about this already because this is a losing issue for voters. And most people getting that question, if you weren't in this world and someone said to you, "Does it make sense to call J.K. Rowling a fascist?" You would be like, "What on earth are you talking about? Like, who's calling J.K. Rowling a fascist?"
Yeah.
Hillary didn't do that. Hillary didn't miss a beat. She answered immediately. So if Hillary knows what's up here, certainly other women at the top do, and men. And we know that they do. We know this because Seth Moulton had something to say. John Ossoff had something. Do you know what I'm talking about?
Yeah. Yeah.
And Seth Moulton just made some very tepid comments, like he just said, we need to talk about this. And he got so much pushback. But even saying we need to talk about this tells you that he knows what's up.
Yeah. Do you think, if you could speculate, what is holding back these Dem allies?
So, oh, these Dem allies. So not the totally in the cult Dem.
Yeah. Yeah.
Well, I think they can continue to pivot and that this will go away. I think they don't understand still the extent to which voters have had it on this issue. And the media does us no favors because we've had some polling that lets us know that this is an issue that voters care about. But the media tends to downplay it. And the media tends to emphasize that voters also care a lot about the economy and immigration, which they do. But I think the media downplays the extent to which this is a real issue for the Dems. So I think the Dems who understand that this is ridiculous, I think they still continue to think they can just keep brushing it off. And, I think it also helps them that Trump isn't really doing Republicans any favors right now. I mean, his approval ratings are tanking.
Fair. Okay, this is an interesting question and comment, and it's really kind of timely. Um, so I will say that I have not seen this clip, so I cannot verify that this is kind of what went down, but it apparently looks like Amy Klobuchar was on NPR, and Amy called the Minnesota shooter he. Um, are you aware that that occurred? Okay. The question is, was it an accident that she's going to have to recant, or do we think that Amy Klobuchar is a closeted ally? Um, I'll take a little stab at this too. I think one of the things we saw directly in the first wave of news was that everyone was referring to this individual as he. It wasn't until I believe that the news was broke on Twitter is where I saw it break, that somebody had found that what's interesting to me is that that was a self-ID situation where that mother filled out a form, took her son to court at 17 and legally changed his name and his sex marker on his driver's license in that state. But I'm not sure. Do you know anything about Amy Klobuchar or
No, I mean, Amy Klobuchar, I think she could go either way. I mean, she's generally a sensible person and, she's kind of a moderate Dem. So I kind of feel like she could be a closet ally or not a closet ally, but she's also not really one to break ranks.
okay, that's fair.
But on the topic of calling him he, most people did it. You're right. Everyone did it immediately because it was obvious that he had a male body. But then even when it broke, I saw something by Stephen King saying
Yes.
Stephen King was
Yeah.
saying, trans isn't the issue, guns is the issue. But what he said was trans isn't the issue, he had a gun. It's even people who, take the side of so-called trans still mess up all the time.
Yes. Um, there was some clarification. Apparently, the NPR interview cut the interview off right after and then came back on to clarify that the shooter identified as a woman. So I think NPR is continuing with their march right off of a cliff. Side note, I think the loss of NPR has made me a worse driver because now I like have to scroll for a podcast when I get in sometimes, as opposed to just being able to put the radio on and be done with it. I'm going to blame my driving on the inability to continue to listen to NPR.
That's
Okay,
fair.
this is a big one for you. What are the reasons the Democratic Party continues their full embrace of gender ideology?
So I think that there are some who are fully in the cult, like Pramila Jayapal. I hope I'm saying her name right. She's
Yep,
got
I
a
know who
son.
you're. Yep.
She's in Washington State. She's got a son who calls himself a woman. And yeah, there are just some that are just completely in the cult.
Okay.
And that's that. Then I think there's the category of Democrats who just think they can continue to brush it off and think it will be okay. And then I think there are some newer Dems who really haven't gotten caught up to speed quite yet. Like they don't really quite understand what's going on here. That's a big part of this whole thing. Why the questioner has trouble talking with her friends in her residence about this is because if you just start talking about how there are convicted male rapists and murderers raping women in the women's prison, it sounds so unbelievable. It's hard to take in. And so I think some of these Democrats, elected Democrats, still don't fully quite believe it. I think it's difficult for many of us who really study this stuff to remember, somebody was asking me, or a bunch of us were talking about why the Supreme Court didn't go as far as we would like them to have gone in Skermeti. We're very happy with the majority ruling, but the opinion itself didn't go as far as I would like it to go, which
It didn't answer, it didn't hit on the fundamental questions. Yes, absolutely. Will you explain that a little bit more? What did they skip over?
yeah, I will, but let me just finish this thought
Sure.
before we lose it, which is someone pointed out, well, the 9 justices on the Supreme Court don't spend all their time on turf Twitter like some of us do. Right. Which is true, right? Like the day
Yeah.
they came out with Skermeti, they came out with one EPA case. They have to deal with so many different things. They're just not as well versed in this stuff as those of us who are unfortunately experts in it have had to become. Um, Okay, so it has always been strange to me that Skermeti was brought as an equal protection case. Skermeti, I'm sure everybody knows, but just in case, Skermeti involved a Tennessee law that said no hormones for minors, no puberty blockers, no opposite sex hormones for minors. It also prohibited surgery for minors, but that issue became moot because none of the kids involved were asking for surgery. So the case was really about puberty blockers and opposite sex hormones. The ACLU represented the plaintiffs, and they brought this as an equal protection case, which I just think is very interesting because They lost so spectacularly, at least at the Sixth Circuit. But anyway, they brought it as equal protection and due process. So under the equal protection clause, it gets very convoluted and legalese. But basically, if someone is alleging discrimination on the basis of sex under the equal protection clause of the 14th Amendment, the court evaluating that claim is going to say, okay, does the law in question involve an important government interest? And is the law in question, does it, I forget the exact language, but it's something like, does it substantially, protect the government interest? There's a test. It's called heightened scrutiny or intermediate scrutiny. And if the law passes the test, it's legal. And if it doesn't pass the test, it's not. And so the ACLU wanted the courts to find that transgender minors constitutes a quasi-suspect class for equal protection purposes, which would have triggered intermediate scrutiny. Sex is a quasi-suspect class that triggers intermediate scrutiny. And so the courts were being asked to decide whether transgender status is a quasi-suspect class. I forget what happened at the district court, but then it got appealed to the Sixth Circuit, and the Sixth Circuit ruled explicitly that trans is not a quasi-suspect class, in part because it's not immutable, as demonstrated by detransitioners. It's not a coherent category.
And also, that was something that was asked of Strangio.
Yeah.
In oral arguments, and Strangio, I think, also basically agreed that it's not immutable.
Chase didn't, okay, to the best of my recollection, Chase didn't use the word immutable. Chase kept responding to Justice Alito by saying that trans, in all of its umbrella types,
Yes.
is a distinct trait. I think that's the phrase she used. So she avoided immutability and called it a distinct trait or something like that. I may be getting it wrong, but it's something like
Yes.
that. So, but anyway, so the Sixth Circuit said that trans is not a quasi-suspect class, which I thought was great. And then it goes up to the Supreme Court, and the six-member majority didn't go that far.
Correct.
It said that the Tennessee law doesn't discriminate based on sex, and it says it doesn't discriminate against transgender people. But the court really tiptoed around the question of whether trans is a quasi-suspect class. And that's why I don't really love the majority opinion, even though I like the vote. Justices Alito, Thomas, and Barrett all would have ruled that trans is not a quasi-suspect class.
Is that a question? Is ruling on that going to be part of the sports case that we'll see coming down?
It will if I have anything to say about it.
Well, yes, we all cheer and want you to have something to say about it. So yes, okay.
I'm sure it will be. I'm sure it will be. And okay, so I am always very reluctant to announce anything about briefs until a brief is actually been filed, because 8 trillion things can go wrong with the filing of a brief. But I will say, with the caveat that something could always go wrong. I'm working on a brief, an amicus brief for WDI USA in those cases, which will rely in part on Justice Barrett's very strong concurrence in Scrimeti to make that argument. But I'm sure the states will make the argument anyway, or at least I hope they will.
Barrett did have a very strong argument in Scrimeti. Yes, absolutely. Were there any other topics that you had covered today in your lecture that you wanted to dive a little bit deeper on if we had some more time?
We did Scrimeti. The reasons the Equality Act hasn't passed.
Go for it.
So this is fascinating to me because this law has been around since 2015. And as I mentioned, it would redefine the word sex to include gender identity for all purposes under US civil rights law, including non-discrimination in places of public accommodation. It would mean the complete end to female-only spaces all over the country. It's been passed in every session of Congress since then, including in 2025. So it passed in the House of Representatives in 2019, and during his campaign in the fall of 2019, Biden promised, I don't mean 2019, I mean 2020. Yeah, 2020. Biden promised to get it passed within 100 days of taking office. So he won and took office, and this bill passed in the House of Representatives in February of 2021. And those of us who follow this stuff essentially panicked because Biden had promised to get it done within 100 days. Democrats had the majority in the House, Democrats had the majority in the Senate. Charles Schumer was at the time the majority. Yeah, do I have that right? Yeah, the majority leader of the Senate. He could have gotten it done, right? When the Democratic president says, get this done, and you're a Democratic majority leader, you get it done. So it passed in the House in February 2021, and we panicked, basically. And we did two things. And by we, I mean WDI USA. One thing we did is we got a letter signed by thousands of women all over the world, thanks to WDI, submitted to Majority Leader Schumer. Now, when I say submitted to, I don't mean we put it in the text of a form and clicked send. I mean, at the time, we had the personal email address of one of his top staffers.
Okay.
In addition to being the majority leader, he's also a state senator from, or a senator from New York. And we had people in New York who were able to set up meetings with some of his staff. So we had the ear of top Schumer staff. And we sent the letter directly to that top staffer. And she wrote back, she confirmed receipt of the letter, and she said, I will be sure to share this with my boss. Now, did she? I have absolutely no idea. If she did it, did he read it? Who the heck knows?
Okay.
But we know it got there. And the matter went before the Senate Judiciary Committee, and I submitted testimony on WDI USA letterhead that made the case that the Senate Judiciary Committee should not pass the bill. And to the best of my recollection, because the Dems were the majority, they did pass it. And then that was March of 2021, and Schumer did nothing. Like, we never heard a word about it again. So Biden did not get this passed within 100 days of taking office.
So
he didn't get it passed within 4 years of taking office.
So it went to die then, quietly, essentially.
Well, yes and no. So in early 2022, it appeared to be dead.
Okay.
Because Congress had changed hands. So even though the House had passed it in 2021, the composition of the House was different. So it was dead in early 2021, or I'm sorry, early 2022. And I thought, all right, this was one of Biden's top priorities. And Schumer didn't get it done. He could have gotten it done, but he didn't. There's no way the Democrats in Congress are gonna, this should have been a major embarrassment for Biden. And I thought, there's no way the Democrats are stupid enough to embarrass Biden again. But in 2023, they proved me wrong. And they proved that they were stupid enough to embarrass the president again. So they introduced it in early 2023, where it went nowhere.
I thought you were going to say they let him go and do that presidential debate and let him embarrass himself then, but we're not even at that point yet.
No.
Yeah. Okay.
So it got introduced in 2023 and it went nowhere. It got introduced this year and it has gone nowhere.
Okay.
So and the really interesting thing to me about 2022 is that it was the 2022 midterms that Republicans got the majority of the House. And Schumer was able to pass marriage equality. There's a federal law called the Respect for Marriage Act. It passed in November of 2022, and it said it was basically passed in anticipation of the Supreme Court overturning Obergefell. Because if the Supreme Court overturns Obergefell, it goes back to the states, blah, blah, blah. So what the Respect for Marriage Act does, it says if you get married in New York or whatever, a blue state, and you later move to Arkansas, even if Arkansas doesn't allow Arkansas same-sex marriages, Arkansas has to recognize your New York marriage.
Okay.
So that's good. but it's also just really interesting to me that Schumer was able to get enough Republican support on that to survive a filibuster, but he wasn't able to get enough support on gender identity
Very interesting.
because I think Senate Democrats know.
We could hope. Okay. I think we have covered all of the questions in the chat. So what I'm going to do now is I'm going to share with you the next 4 lectures in the series that we have lined up and the dates so people can, if you're like me and you have a paper calendar, you can write them down if you'd like. Next up, we're going to hear from Dr. James Cantor, September 25th. Same time. He's going to be lecturing on I am an expert, but don't trust me, how to tell good science from bad. Dr. Cantor and I are often expert witnesses in some of these court case challenges for the ban challenges. So he is quite good at explaining science, especially in a court. I've seen him kind of just knock it out of the park. In October is going to be Lior Sapir, PhD political science. He's going to be talking about the Trump administration's tackling of the question of trans. So we're going to see then and hopefully get some updates on some of these executive orders that have been challenged, if the administration is going on with any further legislative pushes. In November, Sarah Stockton, licensed marriage and family therapist, is going to talk about when or if you should see a therapist and what a parent should know. Kind of questioning a little bit about those concepts around if therapeutic interventions are the right choice, if we've all been therapized too much. I don't know if that's the word. And then in December, Joe Burgo, PhD in clinical psychology, is going to present a topic that he's going to be presenting in Berlin at the upcoming SEGM conference, which is understanding the states of psychic retreat and trans identification. So what is it about in the psyche that people need to kind of go through to retreat out of that trans identification? So I think these are all excellent lectures coming up, and I'm so excited that we're able to put on all of these wonderful individuals, starting with you, Kara. You're excellent tonight. Thank you so much. Kara, if you could just remind everybody where they can find you, so your profile, your socials, all those good things.
Yep, I am at K Dansky on X and Facebook. I have not been able to convince myself to go on Instagram, for which Lauren is always yelling at me. And please check out my Substack, The Turf Report.
And you have a podcast
Yeah, that's on the Turf
on the
Report. Yeah.
Substack. Perfect.
Yeah.
Okay. I also I haven't figured out Instagram yet. I have to learn these one at a time.
Yeah, totally.
No worries. Okay. Thank you so much, everyone. We're going to have this recording available for you all who are paid subscribers to the LGB Courage Coalition Substack. Thank you so much, everyone. Have a great night.